Good morning, members. I call to order the 20th meeting of the Bills Committee on Insurance Companies Amendment Bill 2014. Thank you for coming. We'll continue with our cross-by-cross study. We'll start with Clause 94. That is Schedule 11, Part 2. In other words, for the Chinese version of our marked up copy, page 430. That's for the Chinese marked up copy. The administration has also submitted an index for cross-by-cross examination. You find it in CB bracket 1, 369/14 to 15 bracket 03. And it would also set out the relevant papers as well as the policies involved to facilitate our scrutiny. And then last time, as a result of the lack of time, the administration wasn't able to address the question asked by Ms. Ho. That is, the question concerning the transfer of records by the Office of the Commissioner of Insurance to the Independent Insurance Authority, IIA. Well, of course, we overran our own work after the meeting last time. I was more interested in the software rather than the hardware of the transfer of records. So they gave me an answer after the meeting, but then for the purpose of the record, please give us an answer again. Yes, you raised the question at the meeting. Yes, you got it informally, but then it's better for us to have an official reply for our record. Yes, Mr. Zhang. Well, the OCI, the Office of the Commissioner of Insurance, is required to transfer records and information to the newly set up Independent Insurance Authority. So the question was whether electronic documents would be involved. I would like to refer you to page 225, and we do have a definition. So you can refer to the definition for information includes data, text, images, sound, codes, computer programs, software, and databases. And record means information that's inscribed on, stored in, or otherwise fixed on a tangible medium, or that is stored in an electronic or other medium and is retrievable in a perceivable form. So software and program will be included in addition to the hardware. All right, that is settled. So let's move on to page 430 of the Chinese marked up version. We are now on Schedule 11, Mr. Chairman. When we are finished with that, then we need to move on to the corresponding technical amendments. I just want to notify members that at the next meeting, we will address members' views as well as the views from the sector in one go. So for today, I think it's better for us to finish with Schedule 11. So page 430. Savings and transition arrangements relating to licensing and approval. I think that's more about the procedural arrangements. So when we drafted the provisions, there was already discussion with the sector. It's quite detailed to facilitate members' understanding. We've prepared a PowerPoint presentation. Yes, page 1. Well, within the 3 years of the commencement of the statutory licensing system, for intermediaries already registered with the 3 SROs currently will be deemed as having been licensed by the IIA they don't need to apply again, but then they have to be meeting the licensing requirements before they will be allowed to do so. Next, that's about page 41 of the marked up copy. Starting from that page, starting with subclause 5. That's about the insurance agencies, and that's about the transitional arrangements. So first of all, subclause 5, and that is registered insurance agencies within 3 years of the commencement, they will be deemed as a licensed insurance company. And next, we are showing the scenario that is prior to the setting up of the licensing regime, and if the SROs have already made a decision to revoke the registration before the commencement, then a number of scenarios will also arise. For the first one, and that's in relation to subclause 6 and 7, that's in relation to the following scenario, that is, if before the commencement of the date and the decision of revocation of the registration of the IA hasn't come into effect, and if that person hasn't lodged an appeal, the validity of the deemed license will commence with the commencement date up to the date on which the decision of the IARB comes into effect. And then for the second one, there's clause 9, and that says that if the decision hasn't come into effect after the commencement date, and then the person hasn't asked for a stay of execution, or an application for a stay of execution has been made but then has been rejected, then that license will start with the commencement date up to the time that the decision comes into effect. Say, for example, an application has been made, but then if the tribunal is to revoke the original decision, then the license will be revived once again until the end of the 3-year transitional period. Next, there are 2 other items, and I would like to refer you to subclause 10 and subclause 11. You go to page 433. If the decision of revocation has been suspended, that is, it has been stayed, then subclause 10 says that if the decision has been stayed, then when the stay of execution comes into effect, then the license will be revived, and up to the time when the appeal results in the decision being overturned. If the appeal is such that the revocation decision is to be maintained, then the validity will end with the duration of the decision of the board. Section 11, that is, if there is a stay of execution being applied and granted before decision takes effect, then the validity period will start with the commencement date up to the time if eventually the appeal results in a quashing of the decision, then up to the end of the 3-year period. Otherwise, it will be up to the time when the appeal is to be judged. If members don't have questions, then let's turn to page 4 For this slide, it shows the scenario on page 434 of the marked up copy, subclauses 12 and 13. Before the commencement date, the SROs have made a decision to revoke the license or the registration and has already come into effect, and then the relevant person has been granted the application to stay the execution, and then an appeal is underway. Then for the validity period of the deemed license, it will start with the stay of execution until the outcome of the appeal hearing. If the tribunal is to quash the decision, then it will be up to the 3-year transitional period. If the tribunal is to maintain the decision of revocation, then it will start from that date onwards. Mr. Yu, stay of execution. Are we talking about the new board? From the SRO, the original SRO. So the new board will not take part in the decision. No, it will be up to the existing self-regulatory organizations, the SROs. Yes. We are mainly talking about the IARB, because after there is a decision to revoke, if there is a application for stay of execution, then it has to be applied separately. Later on, when we move on to the other two, whenever an application has been made, then the stay will come into effect immediately. I will elaborate on the arrangements later on. Any other questions? No questions? Then we move on to page 5 of the PowerPoint presentation, and that's about subclauses 15 and 16 of the schedule. It says that the revocation has become effective before the commencement date, and yet the appeal hasn't been finalized. And in the absence of a stay of execution, then the license will have the following validity period. That is, when the decision has been overturned until the end of the transitional period. So the first two red lines that you see on the slide.
Subclause 16. After the appeal is lodged, and if a decision is reversed or confirmed by the tribunal, what will happen in these two scenarios? There is a difference here. And if there is a stay of execution granted, the validity period of the license will start from this oval shape. That is the date of the stay of execution granted, and that is there will be two situations: decision reversed by the tribunal, decision confirmed by the tribunal. Let's move on to page 437, and that has to do with the application for registration with SRO, and his application is being rejected, and then the IAT rejects such or reversed by such a decision. Then the validity period of his license will last from the commencement date to the date when the decision of the application be made, and that has to do with subclause 17. And subclause 18 is that the appeal is not disposed of on expiry of the 3-year transition period. The relevant person can be deemed as having been granted a license until the expiry of the end of the transition period. 19 has to do with appeals to a court of appeal. With regard to the decision of the IAT, if that happens, then the validity period of the license will depend on the decision of the Court of Appeal, and that will be based on the determination of the Court of Appeal. That has to do with section subclause 19. The PowerPoint hasn't provided for such arrangements. Now, if you want to refer to the marked up copy, please alert us. We have moved on to page 438 of the marked up copy already. Please continue. Page 438, subclause 20 of the marked up copy. If a person who is regarded as having been granted a license makes an application for an insurance license, agency license, and for the IAA, then the license will be regarded as having been granted under the section is to remain in force until the specified date. Subclause 21 on page 438 has to do with the licensing conditions imposed by the SROs. After the commencement date, such conditions will be deemed or taken to be conditions imposed by the IIA. In other words, the conditions will be carried over to the new licensing scheme. Page 439, subclause 22. We have earlier provided for a deemed license arrangement, and here we state clearly that a person who is regarded as having been granted a license during the period when the license is in force comply with any condition under sections 21 and 106 of this schedule. Subclause 23. States that a provision in this ordinance relating to a licensed insurance agency applies to a person who is regarded under this division as having been granted a license. If there is no further question, then let's move on to... Sorry? The legal advisor has something to say. In our letter issued on the 5th of May, I have made an inquiry. Section 10 of Schedule 11. We're going back to page 433 and PowerPoint number 3. The question is this. Well, perhaps the PowerPoint shows it more clearly. The way Section 10 is written is this. That is the part without the red line. Does it mean that during this period, the person is regarded as not having a license during that period? So he doesn't. He is not allowed to do any business during this time gap, right? Yes, correct, Chairman. May I refer you to PowerPoint number 3? The third red line relates to Section 10. And that is if there is this commencement date, then there is this time gap until the state of execution order comes into effect. Mr. Yu Si-wing, I would like to ask that during this the appeal period, there is a loss involved because the SROs have made the wrong decision and the agents is suffering a loss. Now, when the new authority takes over, who will bear the responsibility of showing the loss? Is it the SROs or who? Who to take that question? Can you repeat the answer, the question? The loss? The registered organization? Its license has been suspended and by the SRO, and some policyholders make claims or what? No, not the policyholders. the commercial organization's license has been suspended, and during the course you find that there is no problem with it, and it's got his business starting again, and then during that period he suffers a loss in business. And so when his license has been granted again, he can do business again, and he's suffering loss. Who will bear the responsibility of the loss? Under the present SRO system, the licensee is subject to regulation by the SRO, and the licensee has to abide by any order issued by the SRO. Now, if it can prove that it is suffering from a loss, we'll have to look at what actually the loss is. Now, if the license is being revoked or suspended, of course, it is breaking some sort of regulation. And it seems that if he suffers a loss as a result of his license suspension, there is no reason for it to claim a loss against the SRO. So we have to look at the nature of the loss. The underlying principle is that the decision of suspending the license is made by the SRO, and the SRO has to be responsible for its own decision. When the new licensing regime is up and running, what we want to do is that if a decision has not been effected fully, then the legislation empowers the new IAT to deal with the old appeal. So it's not the case that we have a new licensing system and then the appeal has to be discontinued. It has to be carried over. Now, if the three SROs suspend a license, there is no questioning of making a claim to the licensee, right? It must be the case that the licensee's license is being suspended for breach of a regulation. So we have to look at the reasons for the suspension. Well, I don't refer to the case where there will be any appeal or there be any stay of execution. Now, whether his appeal is granted or not, during the suspension period, there is no questioning of making claims for any losses. Is that a correct understanding? Yes, that's my understanding too. Well, don't say that. You have to tell me exactly what is provided in the law. Thank you, Chairman. The legislation doesn't deal with those kind of issues. This is a hypothetical scenario. You refer to a loss. I don't know what you meant by having a loss. Now, generally speaking, the licensee must have broken a regulation, and then he will be penalized by the SRO, and that may be in the form of a suspension of a license. Commissioner, do you have anything to add? As what the Secretary said, under the self-regulatory mechanism, well, this is very much a regulatory system. Mr. Yu referred to the scenario that a licensee may have a license suspended and he may sort of seek a judicial review, take it to court, then that is something altogether different. For our present monitoring or regulatory system, we will not deal with those issues. So under our present legislative proposal and also the existing SROs, there is no mechanism for making claims. Chairman, we have dealt with cases before, and the licensee lodges an appeal of a decision of the SRO. And in most of the cases, the appellants lost the case. And even for the appeal board of the SROs, then he also lost his case, and then he finally took it to a court, and that the process might take a long time. So in the future, there may be cases where the appellant was lodging appeal during the SRO's governance period, and then the cases were taken over when the new IAA was set up, and then the appellant might be involving, they have to pay the litigation costs and so on. And who will bear the costs ultimately? Now, if the SROs made a decision now, and if his decision was reversed ultimately, then the SRO would have to bear any litigation costs involved. Whether any claims could be made would depend on the court's decision. Well, is it the case that the new IIA would not bear the cost of any cases carried over from now? Now, if the SRO made a decision on suspension of license, it will be the responsibility of the SRO to bear any costs involved. In other words, after the expiry of the transition period, or rather, before the expiry of the transition period, for any decisions made by the 3 SROs, they will have to take up the responsibility of the decisions they made. Now, after the transition period expires, when the IIA makes decisions, then it will be the IIA which will bear the responsibility of its own decisions. While generally speaking, that is the case. Is there any exceptional circumstance? Chairman, please understand that this is just a hypothetical situation. This is not a hypothetical situation. We have to be clear about the timing. Well, whoever makes the decision has to bear the responsibility. If the SRO makes a penalty decision, then it will be taking up the responsibility for that decision. From now, say, to the expiry of the transition period, what are the duties of the SROs and the OCI? Are there any overlapping of duties between the 3 SROs and the OCI? Will there be any overlapping of duties? Well, it's exactly because of the need to prevent overlapping. That's why we are making all these provisions. Let me make myself clearer. After the licensing period, regime is in place, it will be the IIA which will regulate the intermediaries and issue licenses. We envisage that in the initial period of the commencement of the amendment ordinance, we will be trying to provide for arrangements during the initial period. We would have to have good arrangements so that the aggrieved parties will still be able to continue with their appeal cases.
Just now, Mr. Zhang talked about the general arrangement. Maybe we haven't got a specific case here. So what is meant by the exceptional circumstances in which we would depart from the general arrangement? Just now, Mr. Chairman, I said that whoever was responsible for making the decision will be held liable. But of course, there may be other details, and therefore when I gave an answer, I talked about the general case. The law is clear. Anything that isn't yet settled, the bill would empower the IAT to deal with any outstanding appeals before the commencement date. Mr. Chen Kin-po, as the representative of the sector, what would you say? I think they are statutory decisions. As Mr. Zhang has said, whoever makes the decision will be held responsible to see whether some mistakes have been committed. It is not true to say that in every case there is the question of cost. Just like in the case of the police, you have to find out whether some thing has been wrong. Now, the court won't force it on you. So to me, I think it's something very simple, very clear. Mr. Yu, do you have other questions? Even the sector has come up with this view. Well, other organizations will be regulated in a similar fashion. So this arrangement may be extended to other authorities, like the travel agents' counterpart. In the past, there was this person who was aggrieved, and then the case was taken to court, and then the judge will try to see who made the decision and who committed a mistake. Now, in the interim, we are told that the original SRO will be dealing with it. But after the transitional period, are you saying that the authority will take it up, or the OCI will take it up? Let me try to explain. Mr. Yu, you were saying that an appeal has already been lodged, and then the case is then taken to the court. It all depends on at what point in time an action is taken. Say, for example, if the SRO, if the appeal has already been finalized with the SRO, then the court will hold that to be liable. But if, say, for example, the tribunal has already taken over the case and the tribunal makes a decision like maintaining the original decision, and then if the case is taken to court, then the court will then check the decision made by the SRO as well as the decision or determination made by the tribunal. And then the details will be checked to see which party should be held responsible. So the court will make a decision accordingly. So when we drafted the provisions, I don't think we have to go so far as to find out who will be found liable or which party will be found liable by the court. Now, we're mainly interested in the transitional arrangements. Now, you refer to the reversal of the decision afterwards. I'm sure the court will make a decision in the light of the circumstances, like who has done something wrong, who should be held liable. So you are saying that if the court case is still ongoing, then the original SRO will be held responsible. But after that, if there is an appeal, then the new authority will be responsible. What do you mean? Appeal to whom? An appeal to court. If the case is an appeal hearing heard by the court, then it is the court's responsibility. Now, if you're appealing against a decision of the SRO, or you are appealing against the decision of the appeal board of the SRO, then the court will make a decision as to the ground for quashing the determination. Well, Commissioner, in simple terms, it means that if the case is taken to the court, then the plaintiff will be the original agent, etc. But upon expiry of the transitional period, the IIA will take over all the regulatory work of insurance agents and brokers. In that case, I want to know IIA will become a party to the case, or whether it will still be the three SROs. Will the three of them still be a party to the appeal? Well, in the case of an appeal, it is not a matter of having parties to the case. Well, when we have an appeal, Say, for example, an appeal against the decision of one of the SROs, the court will make a decision. Then the court will find who should be responsible. Now, for the appellant, if the appellant would like to sue the other party for costs because of damages and loss, then that party will be be asked to take up the responsibility. But then it doesn't involve anything done by the IIA after the commencement date, so it will be the SRO. Well, Mr. Chairman, the greatest worry would be the legal cost. Now, if the regulatory body says that you better do it yourself, now, without income from the members' fees, and if senior counsels and overseas senior counsels have been engaged, then without any income from members' fees, can the IIA be asked to take over? No, I think it isn't a matter of asking somebody to help. If it is related to a matter before the commencement date, then I don't think you can blame it on lack of resources. It all depends on the case, but then what we are really talking about has got nothing to do with that scenario. As to whether the IIA will take up the responsibility, I think it's a matter of those decisions or those cases that are still outstanding. If a decision has already been made, the IIA will not be held liable for those decisions. When there is a court case, I believe that unless there's special circumstances, I just cannot see how and why the IIA should also be dragged in and be held liable. Page 431 of the marked-up copy. And also 437. Now subclause 5, it says that from the commencement date to the end of the expiry of the transitional period, it will be deemed that a license has been granted. In subclause 18, the deeming may extend beyond the transitional period, that is, when the appeal hasn't been disposed of. So it will be deemed that it is licensed until there is a decision about the appeal. On the face of it, the two are inconsistent. So I just want to know if the government would like to consider saying, for example, subclause 18 will still be applicable despite the provision in subclause 5. Government. Thank you for the LA's question. Let me clarify. For subclause 18, isn't so much about what will happen upon expiry of the transitional period. Rather, it is that on the date on which the transitional period expires, and if the appeal hasn't been finally disposed of, then the person will be deemed to have been granted before the expiry of that date. So it isn't anything about the scenario beyond the transitional period expiry date. So that's about the outstanding cases, and we want to say that though it hasn't been finally disposed of, he will still be deemed to have been licensed before the expiry date. Please continue. Page 439. Now we come to Division 3, subclauses 24 to 61. The provisions are exactly the same as those in subclauses 5 to 23. The only difference is that the target has now been replaced by individual agents, person in charge, or etc. So the transitional provisions are exactly the same. With your consent, I would suggest that we don't duplicate the work. With your consent, then we'll go to 457. So that takes us back to the PowerPoint. Yes, on page 6. Savings and transitional arrangements for authorized insurance brokers. Page 6. We want to explain what is in page 457, subclause 62, and that's about a similar arrangement as we have seen already. That is, if a broker has been registered and recognized as a member prior to the commencement, then in the 3-year period between commencement date and the expiry of the transitional period, they will be deemed as to have been licensed. Next, I would like to talk about something similar to what we've seen already. That's about stay of execution and appeal, etc. For page 7 of the PowerPoint, it isn't as complicated as that for IRB. This is because currently for the CIB and the PIBA, their arrangements are such that if the relevant person lodges an appeal, then automatically there will be the stay of execution, and therefore the scenario will be relatively simpler. So on page 7 of the PowerPoint, we try to explain subclause 63 to bracket A and to bracket B. So what is said here is that on the date of commencement, and if the revocation of license hasn't come into effect and in the absence of an appeal, then the license validity period will commence with the commencement date up to the time that the decision takes effect. In the case that there is an appeal, then from the commencement date up to the time that a decision has been made about the appeal, if it is to be allowed and if it is to be maintained. But then if the decision to revoke has been reversed, then the license will have a validity period all the way up to the end of the 3 years of transition.
If there is no further question, let's go back to the marked up copy, page 458. Is not included in the PowerPoint, and that has to do with section 64 and downwards. And these are supplementary provisions, and they are the same as those for insurance agencies. During the transmission period, when there is an appeal not yet underway, then the license will be valid until the expiry of that date. 65. Appeals to Court of Appeal. Well, depending on the decision of the Court of Appeal, the license validity period will be adjusted accordingly. And 66 and 67, as we mentioned earlier, the insurance broker company applies for a license. It will be deemed as having a license, and the conditions imposed earlier on them will remain in effect. And section 68 and section 69 have to do with the conditions imposed earlier, which will also apply to the broker companies after the new licensing regime has been put into place. Mr. Chen Kimpang, IIB, PIBA, and have different approaches. How will IIA deal with it in the future? Would all the decisions be pending once the appeal has been lodged? We have to deal with them separately, the two cases. the aggrieved party can lodge an appeal or lodge for a stay of execution with the IAT. It's not the case that that stay of execution will kick in automatically. So that is a standardized approach between the two associations' rights. Yes. Page 460, Division 6 have to do with technical representatives of approved broker bodies, technical representative, bracket broker, and also the chief executives, the transitional arrangements for them. The provisions are similar to what is set out in PowerPoint 7. So if we don't want to repeat them, we can go directly to page 464. That has to do with the responsible officers of insurance agents, the savings and transitional arrangements for them. The provisions here are similar to those set out in PowerPoint 2 to 5, and that is to the similar arrangements for IARB registered offices. It's just that the groups covered are different here. Let's move on to 467, page 467, Division 8. 474, Division 8, savings and transitional arrangements for chief executives registered with approved broker bodies. Savings provisions are similar to those of the registered persons in CIB and PIBA, PowerPoint number 6 and 7. And let's move on to page 478. Legal advisor. Thank you, Chairman. In my letter of the 5th of May, I have asked a question about subdivision 6 and 8. Both of them refer to chief executives registered with approved broker bodies. There are similar wordings in divisions 6 and 8. Can the government clarify or explain the difference between the two in divisions 6 and 8? Under CIB and PIBA systems, registration systems, if the registered person is a chief executive, he doesn't have to be registered again as a technical representative. But in future, under the new licensing regime, this person has to be granted first a license of a technical representative, and then the IIA will have to endorse its capacity as a chief executive. So, for divisions 6 and 8, they provide for the transition from the capacity of a chief executive to a technical representative, and also the capacity of an approved responsible officer. Let's go back to page 478 of the marked up copy, section 105, miscellaneous provisions. 105 says that the authority may revoke or suspend licenses and approval regarded as granted. And it can also revoke it, suspend it, and also impose new licensing conditions. Mr. Sin, before we move on to Division 9, I have some general questions. You talk about commencement date all the time. Please speak closer to the mic. Would you have phased commencement? If there is a phased commencement approach, what do you mean by commencement date then? We talk about this commencement date of the Insurance Companies Amendment Bill, and that will be announced by the FS in the form of a gazette tool. And there are other commencement dates for other provisions. In some earlier meetings, we said that we would have 3 phases. And before we transit to the IIA operation, we would first set up a provisional IIA. That would be a commencement date for that. And the provisional IIA will take over what's being done by the OCI. The provisional IIA will deal with matters like manpower recruitment and other preparatory works. Second phase, then it will take over the regulatory powers of the OCI and its powers to tackle money laundering. And third phase has to do with the licensing of the intermediaries. You've got a 3-year transition period. The insurance agents are now registered with SROs, which keep records of these agents, and then these records will be handed over in the future to the IIA. During the transition period, is it the IAA which is deemed to be the licensing authority or what? Now, let me supplement. The 3 SROs will hand over the information and records to the IIA. With regard to the administrative arrangement, actually, we've embarked on the work earlier on. We have regular meetings with the 3 SROs on how to arrange for all of these. And now we are already making preparations for the licensing of intermediaries and also setting up the system for public access of information on intermediaries. So we are already doing such administrative work. With regard to the legislation, starting from Division 9, we are setting out how SROs should assist us in our work in the future. So for these 3 SROs, there are legislative provisions requiring them to hand over the records to the IIA. There is a legal basis for doing that. So there is no question about they not wanting to hand over the information. All right, I will follow up when we come to that part. During the transition period, you set out a number of provisions about appeals and so on and so forth in divisions 3 to 8. There may be a need for the 3 SROs to operate until the expiry of the transition period. There may be the commencement date, and then there may still be appeals underway during the transition period. Would all the 3 SROs hand over all the cases to the IAA, or is it during the transition period? The SROs still have to be operating for a while. After the commencement date, the 3 SROs will not operate anymore. And all the records, including appeal cases, cases being handled or processed, and old files where decisions have been made, would have to be handed over to the IIA. The IIA will take over all the cases underway, and also for the old records, the IIA will keep them. And in the future, if there is a need to retrieve such old files, then IIA can do so. So that is the arrangement. Any further question? Mr. Yu. For whatever reason, these 3 SROs will have to close down. Now, will the IIA have to, or the government have to take up the responsibility in the event, their responsibilities in the event that they close down. Well, what period are you talking about? During or after the transition period? Well, whatever, whenever. After the commencement date, then it will be up to the SROs to decide what they would do with these bodies in the future. Now, if there is anything untoward happening before the commencement date, the PIBA and the HKCIB has to get approval from the OCI to operate. So if there is anything untoward happening and then the OCI find it necessary to withdraw its approval, then we'll have to look at what the circumstances are, and we will see whether it will be the OCI which will be attending to these issues. The two bodies have to be are now approved self-regulatory bodies under the OCI. So the authority of these three SROs comes from the OCI, is that right? Yes. So during the transition period, if anything untoward happening to these bodies, then it will still be the OCI which is overseeing them, right? Yes. Now, after the transition period, it will be up to the SROs to decide how they would continue with the operation. It's all up to them, right? Well, it should not be the expiry of the transition period. It should be after the commencement date. The cutoff date is really the commencement date of the ordinance. So before the commencement date, there still remain the self-regulatory organizations, and after the commencement date, they will not discharge any more their regulatory functions. Okay. We are discussing the sections 105 and 106, and it sets out that the authority may revoke or suspend licenses or impose new conditions. Before the IA makes decisions, it should give the relevant person an opportunity of representation. Now we come to section 107 on page 481. In my letter of May the 5th, I also raised a question on this section in relation to drafting. If you look at section 107 in page 478, 3AB, it says that the authority should give the person a chance in writing of his intention or the reasons for doing something before it makes a certain decision. And there are similar provisions in sections 106, 4 and 5, and that is on page 481. I would like you to clarify of the drafting points. Can you simplify the drafting? And that is to combine sections 106, 4 and 5 and draft it in a way like section 105, 3B. Thank you, legal advisor, for your comments. We have considered your view, but in 105, 3B, we think it's not appropriate to adopt the drafting of 106, 4 and 5 because 106, 4 contains much more information than section 105. So to make it clearer and more comprehensible, we think it's better to divide it up into subsections 4 and 5 in terms of drafting. Let's see if members have any other comments. Why are we separating it into subsection 4 and 5? In subsection 4, it only says that a reference to an opportunity to make representations is a reference to a written or oral representation. But in 105, 3B, it's clearer. It's already combined oral and written representations into one subsection.
For 4B, how and when the person may make representations. Is the scope too wide? It means that the person may make representations after a long period of time has elapsed. Could we take this question? Thank you. For 105 bracket 4, as to the question of how, it has to be read together with the subsection above it. So it doesn't mean that it can be taken out of context and that the person may make representations anytime and in any matter. It is in relation to make a representation. That is, to make a representation as to how and when the person may make representations. As to the drafting differences between section 105 and 106, D of J, please amend it if you think that you think it can be amended. But if you think that your current drafting is fine and if our members do not disagree, then that's be it. 482, page 8 of the PowerPoint. Subclauses 108 to 110. And that's about complaints that haven't been disposed of. Section or subsection 108, it says that if a person has complained to a self-regulatory body on the date of commencement, the complaint hasn't been disposed of. That's about 108. For 109, if the complaint is about the commission or omission, and the matter took place before the commencement date, and yet the complaint was only lodged after the commencement date. So in section 110, it says that the IIA may invoke the new statutory powers and process to carry out an investigation, and the complaint may be rejected or action may be taken. At the time that the IIA makes such a decision, reference must be made to the previous standards and the previous penalties. Mr. Sin, again about the commencement date. Just now we're told about the different commencement dates for different phases. I'm not interested in the provisional IIA, but what about commission and omission? Will that be aligned with the commencement date? Well, for the intermediaries, we are still talking about the same commencement date. That is the commencement date for the regulatory system. Prior to the commencement date, the intermediaries will still be following the requirements of the 3 SROs. So the standard of conduct will still be the same. So for PowerPoint, page 8. So you need to rely on the former standards and impose the former or previous penalties. This is to be fair to the intermediaries, because the former standards should have been the basis of judgment instead of making a judgment on the basis of the new standards. Like currently, if somebody is selling an insurance product, then he is complying with the existing standards. Page 484, marked up copy, page 8 of the PowerPoint also applies. And this about investigations that were not completed before commencement date. If there are still outstanding investigations, the IIA will take over. New process can be invoked, but then the penalties and actions to be taken will be the same as those available to the former SROs. Part 7, page 485, that's about the complaints. Please go to page 9 of the PowerPoint. Complaints already lodged, but decisions haven't been made. Now the tribunal will invoke the new statutory process, but then the judgment will be based on the former standards. 114 to 117 are relevant. If there aren't questions, I would like to go to subsection 118, part 8, PowerPoint page 10. Before the commencement date, certain penalties may have been imposed by the SROs. They should be regarded as disciplinary actions imposed by the IIA. In other words, they will come under the jurisdiction of the IIA. But then if a SRO has imposed a fine on a person before the commencement date, and if the fine hasn't been paid, so on the commencement date and after the commencement date, the SRO may regard it as a civil debt to recover the outstanding fine. Page 489. Members have asked this question, and that is the SROs have to provide records and assistance to the IIA. Subsection 120, bracket 1, the SROs have to provide the following records to the IIA to assist the IIA to compile a complete and accurate register of every such persons, and to assist the IIA to see whether a person should be licensed, and also to help the IIA to compile a report concerning the penalties. No questions. Then page 491, section 122. Earlier on, we talked about the records. Once the records have been submitted to the IIA, then once they have been provided, all the powers and responsibilities of the record owner will be transferred to the authority. The authority must ensure that there are proper procedures and systems in place to safeguard against unauthorized access. Mr. Sin, this is about the submission of records and information by the SROs to the authority. Once it has been submitted, then you will regard the relevant persons as licensees for the 3-year transitional period. I'm afraid that there will be cases in which people would try to beat the deadline and try to hastily become registered. Now, there isn't any penalty at all. You just say that the SROs have got the duty to provide the records. That aside, if the records are not complete, say they only give you a name, how can you approve them? Say inadvertently, the SRO causes problems in relation to the transfer of records. What would you do? It won't be as serious as that. Well, I think we can make it simple. The simple case is that if there's no provision, then there is already a penalty in Section 119. Now, I think Mr. 129. Now, Mr. Sin would like to know whether the SROs would be too relaxed in their gatekeeping work. Well, in fact, the SROs have been very vigorous in their process. They have been dedicated in the past 20 years. They have been doing very well as a gatekeeper. So for those wishing to be licensed, of course, for individuals, they need to sit examinations. For companies, we have to check whether the chief executive is a fit and proper person. So the SROs have been doing the vetting process. So we are confident that prior to the commencement date, the SROs will still do a proper job. Well, after they've submitted the records to us, well, there is the deeming provision for 3 years. We need 3 years. This is because we believe that upon the establishment, the IIA needs time to verify the records, because in future the licenses will be issued by the IIA and there's a legal liability. So in each and every case, the authority must be satisfied that the exam has been duly taken, etc., etc. So since we are talking about 80,000 intermediaries and companies, so it takes time to carry out the verification. And that's why we have got a 3-year transitional period, assuming that a case is such that the exams have been duly taken, everything is fine. So within the 3-year transitional period, the IAA will issue a new license directly.
The administration or the commissioner, can you clarify? For these 3 SROs are now under the supervision of the OCI, right? The 2 broker companies or associations are directly provided under the current legislation. It's myself who approved their establishment. And for the Hong Kong Federal, the IARB, it is under the HKFI because it comprises insurance companies. Code of conduct and guidelines, all these have to be approved by the OCI. So it's OCI which is directly and indirectly supervising them, right? Yes, correct. For these 3 SROs, the members or persons in charge are mainly those from the sector themselves, right? Yes. For the PIBA, well, it comprises all brokers. The executive committee is also composed of brokers. But for dealing with complaints and sentencing penalties, well, the disciplinary committee, in the 3 SROs, the composition is different. But in simple terms, some independent persons sit on these disciplinary committees. And in dealing with the complaints, as much as possible, the committee will be chaired by an independent person. There are differences in the arrangements for the 3 SROs, but basically there are people from outside the sectors participating in their work. In other words, before the IIA is established or after the establishment, these members of these SROs are still engaged in the business of insurance. And there is no reason whatsoever that they will try to make things difficult for the IIA. All along, in the past 2 decades or so, they have been very dedicated to their work. Okay, page 492, sections 123 and 124. It has to do with the 3 SROs, HKFI, HKCIB, and PIBA, have to provide the authority with a complete set of rules. Section 125 says that the authority must, after receiving a rule, should publish the rule in the Gazette and make the content of the rule available to any person for inspection free of charge on the Internet. Page 14494, section 126, as mentioned earlier. If a person fails to comply with the requirement under section 120, 121, 123, or 124, the authority may apply by originating summons to the Court of First Instance for an inquiry into the failure, and the CFI can ask the person to comply with the requirement within the time specified, and may punish the person in the same manner as if the person had been guilty of contempt of court. The 3 SROs are organizations and not individuals. I don't know how effective the ordinance is going to be. Now, if you have received the information and you think the information is not complete and you want to take them to court, and after the commencement date, the SROs may have already wound up. So can you take an organization which has wound up to court? What's the point of doing that? What's the use of doing that? The 3 SROs, after the commencement date, may not dissolve at all. They can still remain as industry associations and say to provide training courses for continuing development. In fact, the 3 SROs are doing that right now, and they can still serve as industry associations. And I haven't heard them saying that they would be dissolved after the new licensing regime has been in place. We have set up a working group to provide for transitional arrangements together with the 3 SROs, and we have already gone through all these transitional arrangements with them. And with regard to the transfer of the documents, we've started discussing that since January last year, and we are working very closely with them for the transfer exercise. If there is a new regulatory body set up, it will do benefits to the sector as a whole. On Mr. Sin's question, can I give a brief response here? Mr. Sin is concerned whether the information transferred to the IIA will be incomplete. Well, we'll have to look at the reasons why incomplete information is transferred to us. If the information that they hold is already incomplete, then when IIA receives such information, it will check with the persons concerned and try to get a full set of information. But if Mr. Sin is worried that the SROs are deliberately providing incorrect or incomplete information, then Section 126 can provide for that, and it's targeted not just companies, but rather individuals. We may be asking the chairman, the chief executive officers to provide the information, and then we would be looking whether there is any individual without reasonable excuse or defense provide such incomplete information. If the person deliberately hides information, not giving us a full set, then we'll have to see whether the court how we will deal with it, whether there is a reasonable defense, and so on. If the information all along has been incomplete when it is in the hands of the SROs, the IAA will see if we need to do something more to get the full set of information. We have to maybe do our work to try to find out the missing information. Section 126 refers to if a person or relevant person. Well, these are the words used. So the persons will be held liable. Chairman, may I move on to 495 until the end? These are technical amendments and consequential amendments. If the chairman agrees, then I will not go into the details of these amendments. These have to do with amendments on the wordings. As I said in my opening remarks, Chairman, if that is the case, then we are done with this clause-by-clause scrutiny of the bill. Now, I said earlier that at the meeting on the 18th, we would, in response to views or suggestions raised earlier and views expressed by the sector, we would give a consolidated reply. On the clause-by-clause scrutiny, we are basically done with it. And we will save for the next part of the discussion to the next meeting. Yes, we'll discuss that in the next meeting. Any further views? After the clause-by-clause scrutiny process, we will look at issues raised so far, and also the administration's response, and also CSAs to be moved. Then we will discuss all these in the next meeting. If there is no AOB, then that's it for the meeting today. The next meeting will be held on the 18th of May, next Monday, 10:45 a.m. There will be another meeting scheduled this month for the 26th of May, which is a Tuesday, 2:30 p.m. Okay? All right. So that's it for the meeting today. Thank you very much.